Thank you very much, Mr. Amir, and I hope I'm audible to everyone. Mr. Santhil, can you please again, actually, I think we made the announcement, so please mute your mic. And once I'll complete the presentation, please you can one by one, you can have you can ask the questions. So as Mr. Amir, he actually explained the basic idea was behind today's session to have it for the APC candidates. Since the APC final assessment session is approaching. It will be in May. So we just we planned for it that okay, let's help the fellow aspirants, and so we are hopeful that they are going to benefit from this session today. So then it was the idea of the chairman, Mr. Lake. So he's saying, okay, he said that, okay, let's make it public, and whoever is wishing to join, so he can benefit from this. So I hope all the attendees will benefit from this. So as it is on the RICS competency, so few slides, few initial slides of my presentation today. They will be covering the contract practice and the later slides. I hope that we cover all. So all the remaining slides will cover the contract administration part. So let's start. So first of all, I mean, it's very important to understand about the contract. Let's say that if you want to practice, I mean, if you want to practice in the industry and you want to advise your management in the capacity of being a QS or a contracts manager, so you need to understand the basics of the contract very well. So I'll try to explain some things, so my understanding of the basics of the contract, and I hope that this session is going to give you the brief or a good understanding of the basics of the contract. So the contract is a legally binding agreement between the parties that is enforceable by law. So, I mean, as we speak in Sharia law, let's say that contract is the law between the parties. So for sure, if the Sharia law says or any law says that the contract is the law between the parties, so everything in the contract is enforceable by law, as long as it is not contradicting with the public policy of that country, or it is not contradicting with the law of that country. Everything mentioned in the contract is enforceable by the law. So let's say that if you are from either of the parties, let's say you are working with the client or with the consultant or with the contractor organization. So make it very clear to your colleagues that whatever you are going to sign, please study it well, because this is going to be enforced. So you cannot complain, between the execution of the contract that some clauses were not very clear to us, or it was not the effect of these clauses was not very much clear to us, that it may make some material changes or material effect to the parties. So please be very sure while you are entering into a contract with any other party. Contract is not a whip or a lash. It is to regularize trade and commerce. So what it says, the contract is not a tool to punish someone. I mean, sometimes the understanding we have seen, left, right in the construction projects, that the people they think that this is a tool to punish the other party. Mostly it is the contractor, or the contractor will try to benefit from some clauses. So, I mean, as far as I've seen or I know, and let's say that 80% sure that if you activate your right of any clause just to harm the other party, or just to get the unjustified or a benefit, not just unjustified, but a benefit, just to activate one clause from the contract which can harm the other party. So if you go to the courts, in my opinion, 9 out of 10 or 8 out of 10, it is going to be construed against you. So I mean, don't try to benefit from the contract just because some of the clauses are written. So I've seen this practice that sometimes the contractors are in a position that they actually they have signed a contract without understanding it. They don't have the reasonable skills while they were signing the contract to understand it. So they suffers from the consequences. So just take this into consideration. Contract is an exchange of promises. So what are the promises? You do the work, you do the construction of 30 houses, and I'll pay you. I'll pay you this agreed sum of money in different durations, and many other promises which we see inside the contract. The parties, they agree with each other that yes, if certain situation is there, I'll do that, I'll take this risk, you will take that risk. So the promises are there. So that's why if for sometimes you have to go to the court of law to make a party fulfill these promises. Contract shall be for a legal purpose. This is very important. Let's say we are under the Sharia law, and the parties, the two parties, they have an understanding on the riba or the interest. Interest is illegal in this country. It's not it's prohibited legally. So you cannot sue another party just because they didn't share the interest with you as agreed between you and the other party. So it's not enforceable by law. So the purpose has to be legal in the country the contract is entered into. It has to be legal in that country. So the purpose, also the laws are different in somehow the basics of the law are same, but some laws because of the cultural influences in different countries and by the passage of time our countries developed. So there has to be a legal purpose. The contract creates a legal obligations on both the parties. So let's say that if there is an obligation on the party to perform or to work, and it didn't work or it doesn't perform, so there will be a remedy for that. Okay, the contract creates the remedies also if the parties fail to meet the obligations. So the legal obligations are there, as the contract is the law between the parties. The law between the parties says that you have to perform. So if a party doesn't perform, there is a remedy for that. If a party doesn't pay, there is a remedy for that. So parties are deemed to be of equal bargaining strength while they are entering into the contract. So I think this will take us to the capacity and consent. You have to be sane. You have to be when you're sitting on the table with the other party, you should not be a minor who cannot understand what he's signing. So the law understands that when the parties they signed the contract, even if a guy he's above 18, he is the legal age of consent. So he is deemed of being equal bargaining strength. So you cannot sometimes there is a concept that you demean the other party just because of their looks, because of their age, or because they are contractors or they are subcontractors or they are in a compromising position, which you think. But the law doesn't think like that. The law says that the parties are deemed to be of the equal bargaining strength and they understood the contract well. Okay, so just let me go to the next slide. So for the contract to be valid, there are 5 key elements which you shall take you shall bear in your mind. That these 5 key elements are they will make the contract as binding and valid. What are those? So it says that an agreement between the parties consists of offer, an acceptance of the offer, consideration, intention to create legal relations, and 5th is certainty as to the terms of the agreement. Okay, so I think whoever studied quantity surveying or whoever knows law, I think he knows about this concept, what is offer. But let us delve into the details for a better understanding. So what is the offer? Can anyone please just mention this into the chat box? What is his understanding of the offer? Who is offering whom and what he's offering? Anyone? Do you think that the offer which is made by the contractor, but this is what it means here? Yes, yes, exactly. Offer which is made by the contractor, but also the offer by the employer. So what the employer can offer? What do you think? What the employer can offer? The employer is offering the job. The employer is offering the job of 30 houses. Build me the 30 houses. The contractor says that yes, I accept this offer, and he gave his acceptance through his letter of tender. He submits the letter of tender, he fills the tender, and he sends it to the employer. So he accepted the offer of the client, and he had some consideration. He has some money with the offer. So that is his offer, let's say. So offer is from the both side. Offer is that yes, one wants the job to be done, the other one is doing the job, and he will get paid for it. An offer, if you're working in the tendering, I think you must know about this concept that the offer can be rejected by three let's say three ways of rejecting an offer. One is simply by saying that yes, we reject your offer, or we don't accept your offer, and you don't issue any letter of acceptance or anything, and you don't accept the offer. The second is by conduct. By conduct is that yes, the offer has a validity of 7 days, and you didn't turn back to the parties. For example, the party said that yes, you have to submit your tender within 30 days, but you took within even 50 days passed, and you didn't submit anything. So it means that even if you are pre-qualified, or even if you are among um, the selected tenderers, so it means that khalas, you have not availed the offer, or you rejected the offer. The third is by issuing a counter offer. When a party said that yes, build me 30 houses, the contractor said that yes, I can build you 30 houses, but I cannot build in 3 years. I'll build it in 4 years. So it means that he's not accepting the offer in holistically. So he is just counter offering. So the counter offer is deemed as a rejection of the offer. Okay. Okay. Consideration. Consideration is the money, how the money will be paid. There has to be an evidence that the party is getting paid, or the exchange of promises is being met inside the documents. So if one party is offering the construction of 30 houses, the other party, there should be an evidence that the other party is getting paid for it, or there is a sum of money which is agreed between the parties to be paid. Intention to create legal relations. So usually you know about the letter of intents. Once you accepted the offer, sometimes there is a gap between the acceptance and the commencement of the contract. So sometimes the parties, the party who submitted his offer and his offer is accepted, but he may think that maybe we are not the acceptance is just for the time being, and it is not going to develop or progress further. So the other party says that yes, we have an intention to create legal relation with you. So we'll have a contract, a condition of contract, and all the other appendices of the contract. They agree, the parties agreed between them. So there has to be an indication that the parties, they wanted to create a legal relation with each other. Certainty as to the terms of the agreement. What it says, the certainty as to the terms of agreement is that, let's say, the contract is for the Red Book, FIDIC Red Book, work designed by the employer. But if you go to the contract, the terms are actually for the design. Let's say that all the liabilities of the design are materially lies with the contractor. So the terms are uncertain. The party, they will be confused that what is happening there. I mean, the contract has to be, or the works has to be designed by the employer. So why we are taking the liability of all the design? So the terms has to be certain. The parties, they shall the terms has to be speaking the same language between the what has been agreed, what was the offer, what was the acceptance, what kind of conditions parties agreed with each other, what is the procurement methodology of the contract. So everything has to be calibrated with each other. So the terms shall be certain inside the agreement. So all these five things, they will make up to a valid contract, you know. So sometimes, you know, if some of these are missing, or there is an evidence that some of these or one of or two of these are missing, so this create sometimes disputes between the parties. Sometimes even if you go to the courts of law, they may say that the contract is not valid or not legally binding. It depends. It depends. You know, I can see some contracts which are even entered into without some of these. Anyway, this is the if the parties agreed to this, and parties they are ready to take the risk. So it is to the discretion of the parties. Okay, so this is a small introduction about the FIDIC. What FIDIC is? FIDIC is International Federation of Consulting Engineers. Because we are going to talk about the forms of contract, so I just want you to have this understanding that what FIDIC does actually. Many of our colleagues, they don't understand that what FIDIC is. Sometimes on some contracts, the FIDIC is not there, but it is being referred by many people, you know, as this is the only thing, sometimes the only standard form of contract they know about. So they refer to it too much. So FIDIC is basically the International Federation of Consulting Engineers. It was founded in 1913. Their headquarters is in Switzerland. FIDIC actually publishes the standard form of contract, usually called FIDIC General Conditions of Contract. So they come into shape of books, color coded books, green book, red book, yellow book, and many other colors, silver books. So this is they actually prepare the general condition of contract. So the parties, they take these general conditions of contract. Sometimes they agree with FIDIC. They get a license to go and change inside the conditions of the contract, the general conditions of the contract. So they amend the contracts. So that's what you call as amended FIDIC. Okay. But if you're just taking the book, general conditions, but you are changing you are preparing the particular conditions which overrides the general conditions. So in some conditions, for example, for the payments, maybe the parties, they will, in the particular conditions, they will agree to pay them within the monthly interim payment applications or certificates. They will agree to pay within 28 days from the date of application. So you will see that in particular conditions, while the general conditions will be the same book, which is published by FIDIC, unamended. So somehow you can say that materially the contract is amended, but the book is still unamended. The general conditions are there, but they have been amended by virtue of the particular conditions. So the parties, they agreed something else in the particular conditions. FIDIC actually issued 3 main editions of their books starting in, I think they started way before 1987. So, but what we see mostly you can say an organized edition was in 1987, then in 1999, and lately it was in 2017. Okay, so in FIDIC, we have the complete rainbow suite. Okay, 1999. We'll talk about the 1999 today. We have Red Book, condition of contract for construction for the traditional works or the works designed by the employer. Then we have Yellow Book. This is for the plant and design and build contract mainly. We call them Yellow Book, which are designed by the contractor himself. Conditions of contract for EPC and turnkey projects. We have Silver Book for that. Silver Book, they are sometimes the Yellow Book and Silver Book is used interchangeably. So we'll try to understand that what is the there is a very thin line between these two books. So we'll understand this while we progress in our presentation. So Silver book also, this is the engineering, procure and construction. So the design here again is by the contractor. FIDIC short form of contract. Green book, this is usually the way they say in UK that this is for or worldwide that this is for the projects which are up to $10 million or maybe near or ranging to the same amount because of the let's say that the amount of construction is very limited. The companies involved are very limited or a smaller company. So you don't need that comprehensive conditions to administer this contract. So usually the green book is for the shorter form of or the for the smaller scale works, and it is much more relaxed than we have in red book or yellow book. Okay. Condition of contract for design, build and operate. These are some you can say in the concession agreement. Sometimes you will see these this book being the contract or the conditions of the contract. Model service agreement with the project consultant. White book. I think most of us we know about this, that this is usually the with the consultants you have conditions of contract in this book. So they have been used mainly in Saudi Arabia. We have seen in many projects. Then also we have the condition of subcontract for construction. Red book. This is between the contractor and the subcontractor. Okay. So this is again the rainbow suite that it just give you some brief that if this is a straightforward project, yes, you can use the short form of contract. If no, it's a complicated project, then he divided into different categories. One is the employer design. If the design is by the employer, you can choose the FIDIC Red Book. And in the same setup, if a contractor is he want to enter into a subcontract which calibrates with the red book between the employer and the contractor, so he can conveniently he can use the condition of subcontract for construction with his subcontractor. If it is not the employer's design, then we have yellow book and gold book and silver book, which are designed by the contractor mainly. Okay, so we'll discuss in further details. So actually, whenever the parties they enter into these contracts, so what are the main things which they or the main the rationale behind choosing the different book. So I think somehow we know that how red book and yellow book or silver book will be chosen, but still we just want to discuss this more. So the design risk in red book is held mainly by the employer. In yellow book, it is mainly by the contractor. Employer provides outline design. So not all the time, but most of the times he will the employer will give the concept design. Let's say he want to build a school, so he will just give a concept design of the building, and the contractor he will take further from the concept design until the IFCs and construction and shop drawings. So basically he will do all the constructability reviews and everything is from the contractor. While in silver books, the employer will give the requirements, you know. So I mean, now this is the point where we will make the differentiation between the silver book and the yellow book. So outline requirements can be a simple page or a big book of let's say the requirements of the employer. The silver book mainly actually it is used by between you know in the plants project or gas pipeline or any plants. Excuse me, can you please close your or switch on off your mic, please? Okay. So in the silver book, yes. So outline requirement, the employer will provide the outline requirements. This can be a very simple requirements. So usually in substations, let's say that the employer will say that simply that I want to build a 110 kVA substation. So the contractor, he will be completely responsible for what kind of GIS he requires, what kind of transformers, and from where he will bring. He is responsible for everything, all the specifications, and the employer will have some minimum requirements. Commercial risks are balanced in red book and yellow book, but in silver books they are mainly by the contractor. As we speak, that he will completely take care of the procurement, construction, and engineering. He may, for example, if a building is required by the employer for hospital, so he may bring 3-4 different designs, or he may implement one of these. So this is solely on the discretion of the contractor. So, but only as far as he's fulfilling the requirements of the client, it's okay for him. There will be and there will be no variations. We don't expect many variations in this conditions of contract. So that's why we say that the contractor will completely take care of the things in silver book. Detailed design is by the employer in the red book because it is designed by the employer. In yellow book, it will be the contractor's proposal. As we said that concept design, mostly, not all the time, but concept design will be there in yellow book, and the contractor will propose all the other design, detailed design and IFC and whatever he's going to build. And same for the silver book. The mechanism of compensation in red book is the BOQ mostly, but we have seen some red books which are lump sum. So it is actually the how the risk is calculated between the parties and who want to take the risk, and they agree between themselves. So, but if we talk about the FIDIC concept about red book, it is based on the BOQs. That's why you have the clause 12. The measurement and evaluation, although you have this in lump sum and in yellow book and silver book, but it is actually meant for the red book. While the yellow book, mostly it is lump sum, but I myself, I have worked on a project which is design and build and remeasurable. While the EPC turnkey, yes, they are lump sum, because the risk is completely transferred to the contractor, so it is mostly lump sum. Contract administrator who will do the administration. We need the engineer in the red book because there are, you can say, many operational islands between the employer and the contractor. They are heavily engaged with each other in this form of contract because it is mainly designed by the employer. So you need an engineer or a judge between the parties who can determine, if there is a dispute. So and in yellow book also, the engagement between the employer and the contractor is much more than the silver book. So that's why we have engineer there as well, and he determines and he will issue the instructions, and he will ensure that the works are carried out in accordance with the contract. The parties are fair with each other. The application or the exercise of rights in the conditions of contract, it is justified and the parties are rightful in what they're saying. While in the silver book, as we have spoken already, that most of the commercial risks are being taken by the contractor himself. So this is where we think that, the FIDIC thinks that they don't need an engineer or a party who can be a judge. So it is mainly designed on the basis of relationship between the employer and the contractor only. So because they are not anticipating many disputes in this form of contract, the way they have prepared it or designed it, although there will be, there is no exception in the construction industry. Things happen. So you may see that, but the original concept is that there will be no much disputes. There will be no much things which requires the determination. So it is based on the relationship between only the employer and the contractor. Sometimes, mostly it is understood in the silver book that the employers will not or will have a very limited understanding of the contract. So what or the construction, let's say, if it is a gas pipeline or a substation, so they will hire an employer's representative who can just make sure that when they are going to receive the work, they have to be in accordance with the requirements, So the requirements are implemented, and finally, let's say that if we are going to if the 1 ton kVA substation is functional. So it is energized. It is the connections are going well. The electricity flow is fine. So that's why they require someone very with a good technical understanding who can receive the works in silver books. I hope it is clear to you. Now, there are appendices to the contract. Whenever the parties they enter into a contract, so there will be you can see many appendices. So it's not just the conditions of the contract prepared by the FIDIC or not just the particular conditions. There are many other things which forms part of the contract. So this slides only covers this aspect that you expect that all these will be appended to the contract. So contract agreement, agreement signed between the parties, and they mention the name of the project and the addresses of the parties. So you will see that in a 2 or 3 page contract agreement. This will mention the amount as well, the contract amount or any other very basic information. And this actually this overrides all or not override. Let's say that it actually it is the highest priority document. So you have to be very careful while if you are drafting a contract agreement. So be very careful in drafting that. Contracts data or information, it will be a tabulated form where you mentioned the let's say if the works are distributed into different milestones, you write the milestones. Okay, percentage of retention, so all the things, it will be in tabulated form. Let's say the addresses of the parties, the name of the contractor representative, the name of the employer's representative, all this will be available in the contracts data, or sometimes they say the appendix to tender. So this is what appendix to tender will be. Letter of acceptance. Letter of acceptance is that one the contractor, he prepared his tender, and he will submit a letter of tender. He will submit his price, and with all the other appendices which he thinks that shall be attached to his bid. So he will submit through the letter of tender. So letter of tender, then will the contractor, he has to issue the letter of acceptance for the tender. If it is accepted holistically, there is no issue with the tender. So the letter of acceptance will be there. So it will be appended on number 3. Letter of tender, I already told you. Particular conditions, I think we have spoken about these. General conditions. General conditions are simply the red book or the yellow book or the silver book. If and sometimes there are no particular conditions at all, so you will have only general conditions, or sometimes there will be amended FIDIC red book or yellow book. So you go inside the conditions of the contract and you amend them. Specifications, mostly in the work designed by the employer, the specifications shall come through from the employer. Because it is designed by the employers, the minimum technical requirement or the specifications, so it shall be appended to the contract. Drawings, of course, it is being it is the employer's design. Schedules, not the working or the program. The FIDIC actually does not states the program as a schedule. So schedule can be schedule of rates or a schedule of works. A schedule of milestones, let's say. In yellow book, almost the same. Everything is the same. Employer requirement will be there as we have spoken, the outline design. If there is a concept design, so it can be tracked by the contractor or by the engineer, that maybe if the employer he wants something which is deviating from the concept he has given, or he wants some additional works to be done, so they can be issued as a variation. So it is very important to have the requirements or the outline design appended to the contract. Schedules, again, the schedules, we discussed about this. The contractor's proposal, the contractor's proposal, what he's proposing, let's say for the design or because in yellow book, sometimes you may need to give the design also, some kind of design maybe with the bid. In silver books, as we have spoken that this is mainly all the risks, most of the risks are they are lying with the contractor. So you have very less appendices with this. You will have mainly the employer requirements has to be there, the outline requirement. So if there is any change in the requirement, let's say that the employer says that, you know, my substations are 110 kV, but maybe he need a small substation with it, or he need to increase the load, or the electricity load required is increased. So he will change the requirement. So it will be construed as a variation. Okay, I hope you understand so far. FIDIC actually also, if you see the FIDIC contract, they will give you an ideal project life cycle. That's how the FIDIC thinks that the project life cycle shall be, starting from the tender until the issuance of the performance certificate and releasing the final payment applications. So it starts with the issuance of tender documents from the employer. You can see that. And then there will be a submission of the tender through the letter of tender from the contractor. So this will be called as a tender period. Base date, as actually you can in simple words you can say that base date means that this is the validity of the rates, or yes, the start of the validity of the rates used in the pricing of the tender by the contractor. So base date actually refers to the validity of the rates, or the rates are supposed to be 28 days before its submission. So because at that time he's supposed to be preparing his tender, so he will take the current market prices. So the current market prices, the benchmark for this is this 28 days. So in the FIDIC they are supposed to be from the base dates. So any calculation in the rate changes will be sometimes from base date. So then there is a submission of the tender through letter of tender. Form of tender, sometimes it is called as form of tender also. Then the employer, he will take his time and he will review the tenders from different parties, and he's going to issue the letter of acceptance to one of these. Then between within 28 days, when the contractor, he comes to know that his tender is accepted, and he's going to enter into the contract with the employer. So he will be requested to issue the performance guarantee to the employer. And then in accordance with subclause 8, he will be given, let's say that within 42 days, of the letter of acceptance, he will be given a 7 days period to commence the works at site. He will commence the works at site in accordance with 8.1. And then there's going to be the time for completion, which has been agreed between the parties. Subclause 8.2 refers to that time for completion. Then actually just as an let's say that for just to demonstrate the understanding, or have a better understanding, this table has been prepared in a way that the contractor, he has delayed the project. So there will be an extended period, extension of time. Then on, I mean, when he completed the work, he's supposed to also complete all the tests at completion. So that can be construed as works substantially complete. Then they are going to issue the taking over certificate, the employer and the engineer, in accordance with 10.1. And then kickstarts the defects notification period of 1 year, usually 365 days or 1 year. And it is extendable to 2 years if there is a very valid reason with the employer. But sometimes the parties, they agree 2 years from the outset of the contract. So they issue the TOC, and then the defects notification period of 1 or 2 years. The contractor is supposed to remedy defects for the works he has completed substantially. After 2 years, or let's say 1 year, he can apply for the issuance of performance certificate. Once the performance certificate is issued within 21 days, the performance security has to be returned to the contractor. So that will, and there will be a discharge for sure in accordance with the contract, which will mark the discharge of the parties from any liability from each other. So that is the end of the contract. The performance period, even let's say even the defects notification, DNP also can be construed as the performance period. So the contractor is performing. So that's why the performance security is extended up to this date. Now we'll move to the contract administration part. So these are the core clauses in FIDIC, mainly Red Book. So we'll discuss about the Red Book. Usually, the contract, even if it's not FIDIC or any contract, usually it has it must have, let's say, the obligations of the parties. We have the employer, the engineer, the contractor. Engineer is not the party, but still his role shall be very much clear in the contract documents. If there is any nominated subcontractor, what are his rights, how he will perform the work, and how he will get paid. This has to be there in the nominated subcontractor clause. If it is not FIDIC, any contract, I'm saying staff and labor, how their conduct shall be, how they shall be treated, what are their rights, it has to be there. Plant, material and workmanship, and even the tests which are before the completion, we are detailed in this clause. Commencement, delays and suspension, the time period, the delays, extension of time, damages, rate of progress, all is covered in clause 8. Clause 9 discuss about the tests on completion when the contractor he completes the work. So what are his obligations to how he shall perform the tests at completion, and what are the obligations of the employer in that when he's receiving the works with the engineer. Clause 10 discusses about the employers taking over, how the works or sections are taken over by the employer or by the engineer, and how you issue the TOC. Defects liability period, clause 11 discusses about that. Measurement and evaluation. Clause 12 discusses about measurement and evaluation, and how measurement will be executed, or how it will be carried out. Variations and adjustment, it is very important clause that how the works are varied, and how you approve the variations, or how you finalize the variation. The procedure of the variation shall be there. All these are procedures, starting from, let's say, the test and completion, defects liability, variation and adjustment, contract price and payment, that how the parties they agreed the payment, what will be the payment terms, how what are the requirements of issuing a certificate or preparing a payment application, or the final payment application, let's say, when it is going to be approved. Suspension and termination by the contractor, clause 16. Termination by the employer, clause 15, very important clause. Clause 16, suspension and termination by the contractor. Clause 17 discusses about the risks and responsibilities. Usually, there is a very important clause, subclause in this, which talks about the employer's risks. So the risks he has accepted for the execution of the contract. Insurances, this clause talks about the insurances. The insurances are actually they take effect. What kind of insurances are required? Force majeure, clause 19, and clause 20 about the claims. Actually, we're not going to talk about all the clauses, but we are going to talk about some clauses which are important for your understanding for contract administration. So maybe I'll miss some of those, and we can have another session for them. So general provisions. Subclause 1.1 definitions. It says that definitions of the words and expressions stated in this subclause shall be given the same effect everywhere else in a contract. So what does it mean? It means that I'll give you an example that if you go to the definitions in the FIDIC Red Book, cost with capital C includes the overheads but excludes the profit. Okay, so wherever in the contract the cost with capital C is mentioned, it means that it is exclusive of the profit. There is no profit included whatsoever. But if you find the cost with small c, it can be, maybe it is subjective, but it can be including the profit as well. So it has to be, you have to take these small things into consideration. Notices, let's say that notice with capital N. Usually there's no definition for this in FIDIC, but notice with the capital N, maybe the parties will agree that the parties they can notify each other by virtue of meetings, They had the meeting, and one party they notified the other that yes, there is an event. and this event may rise to give rise to any extension of time or additional amount. So this will be construed as capital N, but it does not necessarily mean that the capital N will be a notice which is written, mentioned, any subclause is mentioned, and it is delivered to the contract through the systems, EDMS or by hand. So I mean, I think you understand this point. The definitions clause is very important. So you have to take everything into consideration. What does the year mean? Year is it 365 days? Or maybe it is 366 days. Even one day in the contracts make a very big difference. So be very specific about the clause 1.1. Clause 1.3 details agreed and identified means of communications, emails, letters, minutes of meetings. Minutes of meeting can be identified or agreed between the parties as express communication method. So if something is given or delivered through the minutes of meeting, this can be construed that yes, it was communicated between the parties, or the other one party communicated to other between the minutes of meeting. But usually, that the concentration usually on the project is to read the letters and go through the letters. So minutes of meeting, they come into a very least priority. So sometimes the party, they have notified of their right or any event in the minutes of meeting, but if they are not an identified means of communication, yes, then you have to rely on the letters only. If they have not informed expressly in a letter or in a notice, yes, then you can maybe the parties, they will lose their right. So this clause also is very important. Subclause 1.5, it's very important clause, subclause. Although the contract documents shall be taken as mutually explanatory, but order of precedence in this subclause to be followed. So as I think we have seen the appendices to the contract. So the same appendices you will see in the 1.5 in the priority of documents. So it will give the priority that the first priority always is the agreement. So let's say that if the party, they have to they are trying to prove their right, or they want to exercise their right. So which is not there in the conditions of the contract. If it is there in the agreement, so they have the right. They are rightful in exercising that right. But having said that, I'll tell you one thing. There is a terminology in the law. It calls lex specialis. So there is a concept driven from this legal terminology. It says that the specifics prevails over the generics. Actually, one of my very good friend, actually, he told me about this. He's my colleague right now. I hope that you have a chance to work with such colleagues who are very knowledgeable. So the specifics overrides the generics. So actually, the law, I'll tell you what is the law. The law is that in a general rule of law, if I'll give you the example, if let's say some people are exempted from the tax in general rule of law, but there is a taxation law issued by the country. In that taxation law, it is very much expressly mentioned that these parties or these people are subject to the tax deduction of tax. So the specifics will prevail the generics. So the party, they cannot take the benefit of the general rule of law. So the same concept here is that the specifics prevails over the generics. So if something is specifically written in the contract, expressly stated, so and let's say that the agreement says something else. So sometimes it can be construed against the party who want to take the benefit of this general rule of or general or generic statement. So specific statements have more weightage sometimes than the generic statement. So that's why we always say that the contract documents shall be taken mutually explanatory. So you don't run to a conclusion when you see your right being expressly stated in. Let's say that it is not expressly, but somehow implicitly stated in the agreement, but somewhere in the lowest priority document it's expressly states, then that will prevail. So just you have to take your time in building up the your opinion about your rights and the other parties' rights. Clause 1.13, employer gets his permits, contractor to comply with local laws. So usually I'll tell you just a brief that sometimes usually the parties they agree in the contract that the employer he will get the zoning permit, the land permit is with him. He will go to Amana, usually the municipality here, they will go to the municipality. Municipality actually they have the master plan for the city, so they will tell them that this area, certain area, I'm going to use for the construction of let's say a 5-star hotel. So and he's going to present his master plan, a master plan for that particular development. So the municipality they will take this into consideration and they will make this as part of the city development. So that permit shall be taken by the employer himself. So he cannot wait for the contractor to come and get this permit for him. However, the other permits, for example, execution of construction, the construction execution, let's say that crusher, crusher, there has to be a permit. Excavation by blasting, there has to be a blasting permit. The contractor he shall comply with the law. Sometimes I've seen on my project sometimes there is an issue with the dust suppression. We are doing the infrastructure. Mostly it is excavation and earthwork. So there is a lot of dust. So the environmental control center actually they will issue some penalties, to the contractor, because he's supposed to respect the local laws. He has to control the environment. He shall not make the environment contaminated. And you have the classic case of asbestos. If you go and work in UK, it is the laws are very strict there. So the contractor shall comply with the local laws. 1.14 also, let's say that if your contract is JV, so you shall know that both parties are jointly and severally liable to the employer for the performance of contract. So what it means actually, the jointly and severally liable, it means that let's say during the JV is between two contractors, and one of the contractor he runs away, between the execution of the contract. So the employer he can pursue his the damages he suffered just from the one party who is existing. So it doesn't need to be both the parties, because both are severally liable for the performance of the contract and any other damages they will incur, or they will harm the employer. So that's what it means actually, the several liability. We'll move to the next. Yes, it's very important. Clause 2, the employer. Subclause 2.1, the employer shall give the contractor access to the site and possession to the site. By the way, this actually, the more you delay the access to the site, the more you delay the performance of the contractor, and it's a blank check for recovery of cost and profit and extension of time. The delayed access to the site. Access to the site, sometimes it means that sometimes the contractor also think that the access to site means that there will be a road going to the project. So it does not mean that it shall only be the let's say the coordinates of the site or the area of the site which shall be handed over to the contractor. He is supposed to build the access to the site, the way which goes to the site, the gate and the security. This is all his responsibility. So access to the site, it means that only giving the site to the contractor for the performance period. So the site will be under the control of the contractor for the period which is stated in the contract as the project completion, and he will have the possession of the site. Subclause 2.2, assist the contractor to obtain permits, licenses, or approvals from the authorities. Sometimes the situation happens that if you go to the municipality, so municipality, they don't recognize any specific contractor. So sometimes they will delay their approvals or permits. unless the employer which is recognized inside the municipality, and he has taken the permit of or the zoning permit or the construction or the overall development permit, so he will be identified as the main responsible. So that's where the contractor, he will need your assistance. So it's not that you cannot ignore the contractor from giving him this assistance. At the end of the day, it is your project as an employer. So if the contractor delays it somehow, the project is not going to be delivered on time. So you will suffer delays. There will be some consequences. So the employer shall have this understanding that he has to assist the contractor to obtain permits. Subclause 2.3, the employer to ensure that the employees cooperate with the contractor. What does it mean actually? Sometimes the employees of the company, just because they don't like some people in the contractor organization, so they make the performance of the contract very difficult for the contractor. Sometimes they will terminate some people, or not terminate. You cannot terminate but you can just simply you can complain of their disorderly conduct or misconduct, so which will compel them to terminate the employee. So if, let's say, if suppose that this goes every 12 months of the year, it will be very difficult for the contractor to work. Sometimes, let's say that if the security is under the control of the employer himself, it is let's say if you are in the Aramco side. So if, let's say, the Aramco, they will take in the morning, when you go inside the site, so you can see a big line or a long line of the laborers. So if they take 15 minutes, usually they can just take 5 seconds to enter the laborer. But let's say if they implement a system which takes half an hour for the labor to enter inside the site, so you will have the laborers still trying to get inside the site when it is already 5 p.m. So I mean, the concept is that the employees of the employer organization, you have to make sure that they cooperate and they don't make it difficult for the contractor to work or perform. Subclause 2.4, very important subclause. It provides that the employer, he has to provide the reasonable evidence of the financial arrangements he has, and the contractor is as adversarial as that the contractor can or is entitled to suspend the works if reasonable evidence is not provided in 28 days. Let's say that the employer he's just he has a loan from the bank, and the loan says that yes, it's only for this year, and it's not for the next 2 years the contractor is going to perform. So it will show some funds only for this year. So maybe the contractor will not be satisfied with this evidence. So the employer and so on. I mean, there can be an event that where the contractor is not actually satisfied with the evidence provided to him, and for sure he has everything at stake. He has all the equipment and laborers, and sometimes there are thousands of laborers at site, so he cannot afford them to not get paid, or sometimes the cash flow is not helping him to pay to such a big pool of laborers. He actually he's rightful in asking for the reasonable evidence of the payment or the financial arrangement. Sorry. Subclause 2.5, give notice to the contractor of any claims. If the employer consider himself entitled to any claim, he shall give the notice in accordance with subclause 2.5, but except if he is providing any electricity, water, gas, or any equipment or any free issue materials, or services to the contractor. He can, without even giving the notice, he can just adjust them in the monthly payment applications or certificates. He can just simply tell the engineer that yes, I have these deductibles, so please deduct them. So no need to give any notice for these things, except all these electricity, water, and gas. If there is anything else, he can give the notice to the contractor that I'm entitled to the cost and in this for this subject. The engineer. Clause 3, the engineer. Subclause 3.1 actually makes a very important statement inside this subclause that the engineer have no authority to amend or relieve the parties from their obligation under the contract. So engineer cannot amend the contract. He is just there to administer the contract. So be very specific about this. The engineer shall not engage himself into such endeavors that he end up amending the contract. He shall have the express authority from the employer to amend the contract. So usually the employer organization doesn't give such authority to them, and they cannot even relieve the parties from the obligations. Let's say that if there is a determination by the engineer which materially relieve the contractor or the employer from his obligation, so it is unlawful. He cannot relieve the party. Let's say that there is a valid payment from the contractor, and the contractor, he submits his notice that I want to get paid for my works, and by chance the engineer says that you'll not get paid. You'll not be paid, although the payment is an obligation on the employer, so he cannot relieve. Even if he says that, he cannot relieve. If you go to the courts, the employer will not be relieved. Even if he says that no, because engineer has said so I'm relieved, he will not be relieved. Subclause 3.3, contractor must comply and may only take instructions from the engineer. Yes. The engineer can issue instructions to the contractor at any time, including additional or modified drawings, which are necessary for the execution of the works. So the contractor actually, just to maintain the fairness, or that's how FIDIC thinks that if you want to maintain the fairness, the instructions can only be by the engineer. Maybe they have some lesson learned from their previous experiences in the form of contract, that maybe if the instruction is by the employer in red book or in yellow book, it has some different effects or consequences. So the employer can only shall take the instructions from the engineer. Also, I've seen a tendency that the employers nowadays, they have good employees with them, very let's say very skilled. So they try to engage directly with the contractor, so which is not a very good practice, by the way, unless there is no other choice. But you shall stay away from, if you are in the employer's organization, because I am in the employer's organization. So usually I say that we have to stay away from or minimize the direct correspondences with the contractor directly. So it shall be through the engineer. So they are monitored. The engineer is there to administer the contract. So if we have any rights, at least we can notify the engineer. The contractor, the contractor, he can keep saying that yes, I have a right, or the vice versa. The employer can keep saying, because these are two parties to the contract, so they may not accept each other's point of view. So that's why the engineer is there. 3.4, the employer can replace the engineer with 42 days notice, and contractor may object to this. Usually the contractor may object to the appointment of the new engineer. Maybe there is any conflict of interest or any such case. So we can object to the appointment of the new engineer, or maybe even the previous engineer. Maybe there are some determinations pending with him, or the employer, maybe he terminates him, or the engineer may be citing some determinations which can go against him, which he thinks. So he can terminate. At that time he may terminate the engineer. So he may object. The contractor may object to the termination of the engineer, and because employer is the one who appoints the engineer, so he is the only one who can terminate the engineer or replace the engineer. Sorry. Subclause 3.5 is determinations. The engineer shall endeavor to reach an agreement between the parties if there is a dispute. If no agreement is achieved, he shall make a fair determination. So 3.5 actually, 3.5 is very important. Actually, 3.5 is, you can say, this is a legal right, or a legal. The effect of this is legal. If the engineer, he has make a determination, the determination can only be, and it is in the next in the next line, both parties to give an effect to the determination unless until revised under subclause or clause 20. So it is only the engineer who can revise his determination, or it can be revised by virtue of dispute adjudication board. DAB may revise his determination if they think that it was not fair or it was not proportionate, and maybe if not DAB, or if DAB, then arbitration as well can change the determination. But it is something legal, it has a legal value. The determination of the engineer, you can go to the courts and let's say that maybe it will be valued there, or it will be considered or construed as a legal instrument, the determination of the engineer. And both the parties, they have an obligation to give the effect to the determination of the engineer. If they still, let's say that they are dissatisfied, or they are not happy with or one of the parties is not happy with the determination of the engineer, so he can give a notice of dispute or bringing the dispute adjudication board in accordance with clause 20, but still he shall give the effect. If the determination of the engineer says that the employer shall pay 20 million reals to the contractor, he shall pay. And when he will get a revised or a different decision in the DAB, yes, that has to be given the respect as well, and that shall be given the effect at that time. But until then, he has to give the effect to the determination. We'll move to the obligations of the contractor. In accordance with the contract, principally subclause 4.1, the contractor is to execute the works, provide the plants, and be responsible for the capability, stability, and safety of the works. As we have seen already, the subclause 4.2 states that the contractor, he has to deliver the performance security to the employer within 28 days of the letter of acceptance. Subclause 4.3, the contractor, he has to appoint an authorized contractor's representative who shall be addressed in the correspondence by the engineer or by the employer if needed. The subclause 4.4 says that he shall not subcontract whole of the works. So this is something which can lead to termination of the contract if the contractor he subcontracted the whole of the works. In the traditional setups, I think you will find this in the maybe tender and procurement law of the Saudi government, that he shall not subcontract more than 35% of the works. So sometimes, if the parties they agree, it can be 50% as well, but he shall not subcontract the whole of the work. Only it has to be a management, let's say the procurement strategy has to be the management contracting or construction management. That's when he can the works are wholly given to the subcontractor. But in the traditional setup, no, he shall not. Subclause 4.4 continues. Before engaging the subcontractors, the contractor shall obtain the consent of the engineer. He shall submit. Usually, we see on the projects that the contractors, they submit the approval of the subcontractors minimum 28 days before the commencement of the subcontractors. So this is just to administer the time. They bring them timely. So I mean, it's not that tomorrow the subcontractors shall be engaged on the site and they create a hassle to get the approval just on before one day. So he shall give the proper time to the engineer to assess that the contractor is qualified, he complies with the project requirements, and maybe there is a list of approved subcontractors, so he is one from them. So this is to administer those aspects. Subclause 4.6, the contractor, he has to cooperate with the engineer and the employer staff, vice versa. We had this in subclause 2.2 or 3, that the employees shall cooperate with the contractor, and the contractor shall also cooperate with the engineer and employer staff. Sometimes again, the security of the site, let's say that he wastes the time of employers, employees, and engineers, employees, on the gates, and makes it difficult for them to enter into the site, and so there is a stuff like that. So it shall be avoided. He has to cooperate, and any other, if he's working in let's say in a bigger development where other contractors are working as well. But like we have NEOM or Kidia, so he shall cooperate with other contractors as well. He shall not make execution of their works difficult for them, because sometimes maybe there will be concreting at the same time. There will be some activities at the same time, so there will be some logistic issues. There will be many issues. So the contractor, they actually and he's supposed to cooperate with all the other parties there, or the engineer, or anyone else there. He has to cooperate. He has an obligation in accordance with the contract. Subclause 4.11, very important subclause. The contractor is deemed to have satisfied himself with the sufficiency of the accepted contract amount. So this subclause actually binds the contractor to stick to, if it is a lump sum contract, let's say. So it binds him to stick to the accepted contract amount, which is signed in the agreement. He cannot say, let's say that a month after starting his execution of work at site, that now the rates have increased, and sorry, not the rates have increased. I have missed some aspects of the project. I have missed pricing some aspect of the project. So he need to satisfy himself that the accepted contract amount which I've signed, it calibrates with the drawings have been provided, the data have been provided, and I have covered everything in this accepted contract amount. It is full, and only accept the variations and claims. Subclause 4.12, notify the engineer if the contractor encounters unforeseeable physical conditions. This gives rights to the extension of time, and sometimes it's even for the employer, there is no enough time to do a comprehensive soil investigation. So it will be the contractor will build his prices on the basis of the available data and the visits he will once he is going to take the visits of sites. So he will build his and the available data he has. But when it comes to the site, it seems that the substrata is completely changed, and it's actually completely loose soil instead of rock. So maybe he need to do some soil improvement on, so he can come and say that, the physical conditions are unforeseeable. I cannot foresee on the basis of the data provided to me. I can now see that I can foresee that it is going to be rock or loose soil. And let's say if it is rock, so then excavation is difficult for him. So the means of excavation or the rates of excavation will be increased. And if it is the loose soil, so then he has to do the soil improvement, and it is going to cost him a lot more. So he's eligible for time and cost for this, and maybe profit. We will see in the next clauses. Subclause 4.15. The contractor deemed to have satisfied himself with the availability and suitability of the access to the site. Sometimes the sites are in the dense population. So before entering into the contract, he is deemed to have satisfied himself with this. Maybe because this will be included in his prices. That let's say that the concreting can only be done in certain hours. So it's not a site which is secluded from the city, and he can perform at any time. He can do any activity at any time. But in the center of the city, you have certain limitations. So you cannot complain once you enter into the contract. So you have to understand your contract very well. That what the conditions of the site, and maybe like we have in Saudi Arabia, Aramco. They have as in accordance with the temperature of the site. Maybe the work will be stopped for 3 hours. So sometimes the contractors say that this has not been taken into consideration in our program. So maybe this will lead to extension of time, but not no extension of time. You shall have you are deemed to have satisfied yourself before entering into the contract. 4.19. Be responsible for all power, water, and other temporary utilities and services required for the works. The contractor, he need to check that from where he's going to get the power. Maybe a temporary power source near to the site, or maybe he will have generators, water. From where he will get the water, he need to bring. He need to have resources available to him. Uh, and he need to be responsible for all power, water, and other temporary utilities and services. Let's say that if the employer provides him these services, for sure he's going to deduct it without any notice, as we have discussed before. Subclause 4.21. The contractor, he shall issue the detailed progress reports on monthly basis. It's very important, by the way. He shall submit the monthly updates to the engineer. Sometimes, when you are at the you are doing a delay analysis, forensic delay analysis. If you don't have the progress update, sometimes it goes against the contractor, the window analysis. Maybe the result of the delay analysis suggests that the contractor is in delay, while maybe in his program he has shown some different kind of progresses. So if it is not completely there, the monthly updates, and the contractor is only updating after 1 year or 6 months, is not the right practice. So he shall have all the XCR files also shall be submitted with his monthly updates, and he shall ensure that he submits. It's not for him, for his sake, also for the engineer and for the employer, to make a right judgment for the engineer at the time of delay analysis. Subclause 4.22. The contractor shall be responsible for the safety and security of the sites and keep unauthorized persons off the site. This is very important. There is usually there is a theft on site, and there is by the way, I think maybe we have seen some very suspicious activities on sites, sometimes. So this is just because of the unauthorized persons entry into the sites, and it is later on it is discovered that some unauthorized persons were there, and they were doing some suspicious activities. So the contractor is the one who is responsible for the safety and security of the sites, because he has taken the possession of the site. Subclause 4.23. Keep operations confined to the site or any designated area. Sometimes you have neighborhood and the contractors, just because they have a limited time of completion, and they are in hurry. So it seems that the neighborhood is affected by his operations at site, or maybe the adjacent properties, and he's damaging them, or he's very much wavered in his performance. So he shall keep the operations confined to the site. Otherwise, he will be liable to the damages he will cause to any other party. And there is an insurance for that as well. Third party liability, or any property or person's damage to third party. Subclause 4.24, it talks about the fossils. If there are any fossils or items of geological or archaeological interest from the site, the contractor is supposed to notify the engineer immediately upon discovery. And he shall not do anything with that unless it is reviewed by the engineer, and maybe sometimes it needs some authorities, some geological authorities to come and to have a look, and then he can resume the operations at site. This gives him the entitlement to cost or time, if let's say that if he's delayed because of the subclause 4.2. Next clause which we will discuss is the commencement, delays, and suspension. As we have discussed before, subclause 8.1 discusses that the engineer gives a 7 days notice to the contractor to commence within the 42 days of issuance of the letter of acceptance. And that will be marked as the commencement date of the project, and the performance period of the completion of the project will be calculated from the commencement date. So sometimes there is a confusion between this, so the commencement date is which is in accordance with subclause 8.1. So be very careful while you communicate this to the contractor, or you're from the contractor side and you see this, so record this very carefully. Sometimes there is a dispute between the parties just on the date of commencement. Subclause 8.3 is regarding the submission of the program. The contractor to submit his detailed program, commonly known as baseline schedule, within 28 days of the commencement. So he shall submit to the engineer the baseline program. The engineer to review the program within 21 days of receiving. So the reason I've underlined this, that we hear the terminology on the projects that approved baseline. So approved baselines means that it is consented baseline. So the program is not meant to be approved by the engineer. Engineer, he need to make sure that it has to comply with the contract. The dates there are in accordance with the contract. The distribution of the milestone is in accordance with the contract. There is a logic link between the activities. Let's say that, I mean, you have reinforcement, and then you cannot start the tiling for sure, you know. So he shall review from this perspective, but he shall not approve the program. Approval of the program actually is usually why FIDIC says that you don't approve the program. Let's say that the contractor he submitted his program, and he has the deployment of resources is because he is the one responsible for the execution of the site, and he has to comply with the performance period. You know, the completion date shall be respected in his program. But he has mobilized the resources in a way that which suits him, you know, because sometimes, for example, the tile fixers will come, let's say maybe after 1.5 years of a 3 years project, or maybe 2 years, you know. So he don't need to mobilize them from the start of the project. So this is his program. That's how he's going to mobilize the resources. But if you are trying to influence his mobilization of the resources, if the contractor is aware enough, or if he understands this concept, he can come back and ask for a variation that, you know, you incurred the additional cost to him, you know, because the comments you have given, or because you rejected the program just because of some mobilization of the resources, you know, it increased my cost, you know. So that's why the FIDIC says that you don't approve the program. You just give the consent that I have reviewed, you know, just take your time, or even you don't need to give the consent. The consent is given if you don't give any comment within 21 days. So this shall be understood that the program is not meant to be approved. So there is nothing called approved baseline schedule. Yes, there is a baseline schedule, which is the contractor's program. Subclause 8.4, I think we all are well aware of this subclause. It is extension of time. If the contractor feels himself entitled to the extension of time, he shall give a notice in accordance with subclause 21.1, which is contractor's claim. Let's say that the next sentence is the engineer may increase but shall not decrease the EUT. So what does it mean? That maybe the contractor the contractor he submit his extension of time in 3 different timings. Let's say in the start of the year, and one at the end of the year, and one maybe at the end of the next year. So let's say that engineer he has given a determination in his previous extension of time, and he has given him 100 days. While he's supposed to review all the program and all the activities when he's going to submit his next extension of time. Now he cannot reduce it to 80 days. You know, he can increase it to 120 days, or let's say that maybe he can keep it 100 days. You know, if he thinks this way, but he shall not decrease the already given extension of time. Subclause 8.6, if the rate of the progress is too slow of the contractor, so the engineer may instruct the contractor to submit a revised program. We commonly call it as a recovery schedule. So recovery schedule is that you keep the same completion date in the program, and all the activities you just try to recover the delayed the delays already there in the program in the progress updates. So what you will do, you will maybe change the resource planning, or you maybe you will do some endeavor to try to complete the work in time. So you recover your delays. So this will be called as the recovery schedule. We'll move to the variation adjustment. Very important clause. Subclause 13.1. Any changes to the work which is adjusted, instructed, or approved as a variation under clause 13. So in order to be a variation, both the parties, they shall agree. This is what it means by this sentence. It's not that I, as a contractor, I think that this is a variation, so this will be construed as a variation in my calculations or when I'm submitting my payment application. So variation has to be agreed by the parties, both the parties, and vice versa. It is same for the contractor. It has to be agreed and accepted by both the parties. Subclause 13.3 details the VO procedures. The VO procedure says that the engineer requests a proposal from the contractor for any additional work. The contractor, he submits a VO proposal, including the cost and time and the effect of this variation into his program. Maybe it will end up in extension of time to the contractor. Maybe the engineer approves or disapproves in writing, and then the variation is commenced. So again, I mean, saying the same thing, that yes, it has to be agreed by both the parties. Subclause 13.5 talks about the provisional sum. Each provisional sum shall only be used in whole or in part in accordance with the engineer's instruction, and the contract price shall be adjusted accordingly. So the provisional sum, if it is in accordance with the red book, there has to be an engineer's instruction to discharge the provisional sum. So it cannot be discharged, or it cannot be taken into consideration, or the contractor shall not execute until he receives an instruction from the engineer. I think I mean, all the attendees, they have discussed or they have attended many webinars on variation. So I think we don't need to, because we have some other subclauses. So it's better to go next without even, I mean, let's say, wasting our time more on this clause. So clause 14, contract price and payment. Subclause 14.3, the contractor, he submits his application for payment. The first, you can say the first line, it shows how the 14.3. I think you all know about this, but just let's discuss on this. Subclause 14.3, application for interim payment application. Usually the contractor, he submits his monthly payment application at the end of each month, but that's how it is written in the FIDIC, but this is not the case. He will complete the month and he will submit in the next month. Sometimes the cutoff date is 25, or if it is 30, so for sure he's not going to submit at the end of the month, because the work has to be, there has to be WIRs and there has to be approvals. So the contractor, he submits his monthly payment applications, monthly IPA to the engineer. Engineer, he has 28 days to issue the interim payment certificate. This is a requirement of the subclause 14.3, that the engineer, he is obliged to prepare or issue the certificate if there is no other any serious concern or objection by the engineer in the normal course of work. He has to issue the interim payment certificate within 28 days. The employer, and the subclause 14.6 creates an obligation on the employer to pay in accordance with 14.6. So whatever has been approved by the engineer or certified by the engineer, this creates an obligation to the employer to pay in accordance with 14.7. So sometimes, the engineer, they can make mistakes. They can add some amount which is not justified. So it does not mean that the employer will not pay. or he can simply pay, and then the engineer, he can adjust this in the coming months. So usually there is no time for this, the correspondence back and forth. So to avoid wasting time, so the employer can pay, because the 14.6 creates an obligation on him, the legal obligation to pay in accordance with 14.7. So the adjustments or the revisions can be done in the next month, in the coming month. Then the second statement which we have in the FIDIC contract is the statement at completion. So usually we call it the final account. So final account usually in accordance with FIDIC, it is executed in two stages. The stage number one is the subclause 14.10. The contractor issues a statement at completion. So when does he issues? When he received the TOC, the issue, the taking over certificate from the employer. So within 84 days of the issuance of the TOC, he will submit his statement at completion. So I mean, I would like to assert on or reiterate on within 84 days. So usually the clauses are there in the contract, but it depends on how you interpret. What is your understanding? 84 days or 84 days is not the minimum, or it is not the exact time which need to be observed. 84 is the maximum. So you can the parties, they can actually let's say minimize the duration, because it states that within 84 days. It does not states that exactly in 84 days or on 84th day. So if you are in a good faith obligation with each other, and you have to be for sure, so you have to interpret the contract in with the objective of completion of the works, not to be a showstopper, or sometimes the understanding of the contract administrator is that just we have to stop the show. So this is not the intention. The contract is written in a way that the works has to be completed. The show must run. Show must go on. So 84 days. 84 days is within 84 days of the issuance of the TOC, the contractor, he will submit his statement at completion to the engineer, and then it will be the same procedure as the monthly statements. The engineer will have 28 days to review and certify. The employer will have 56 days from the submission of the contractor. We'll be very careful on this. 56 days, not from the certificate. 56 days from the application. So there is a date of application from the contractor, and that shall that plus 56 days will mark the payment date in both the in monthly statement as well as in the statement at completion. While we issue the TOC, and after the issuance of the TOC, we have subclause 14.11. This is the second stage of the final account. This is called as application for final payment certificate. Defects notification period, the contractor will remove the defects within this time, and this is sometimes extendable to further 1 year. So maximum is 2 years. This is what FIDIC says. It can be more as well, but I haven't seen so far. It will be unjustified with the contractor to be the defects notification period to be 5 years or 3 years. So 11.1 defects notification period. Then after the completion of the defects notification period, the engineer is, or the employer is going to issue the performance certificate. Usually the engineer will issue the performance certificate to the contractor. When he's not under he's not required to perform anymore in accordance with the contract. So basically the performance period is the contract period, when he completed the work. But because he's remedying the defects, and he's still working to remove some defects, so maybe there can be some harm to or let's say some damage to the permanent works. So he's still under the obligation of the contract. So that's why the performance security is taken up to the end of the defects liability period. So within 56 days of the issuance of the performance certificate, the contractor, he can issue his final payment. Sorry, the engineer. Okay, the contractor, he submits the application for final payment certificate to the engineer. So then it has the same effect in accordance with clause 14.6 and 14.7. The engineer, he has to certify it within 28 days and within 56 days from the issuance of the application, the employer, he has to pay the money. So sometimes, there are issues between the parties, some claims to settle. So I think this structure gives a lot of time to the parties to settle the claims and to agree on the claims, even if it goes to arbitration. So I think by the time we have final payment certificate, we can settle all the things. Subclause 14.10, I would tell something that how it looks like, or what shall be considered inside the 14.10. The retention, 50% of the retention, the 5% retention, it has to be paid back to the contractor. Usually it is accepted contract amount. There is a difference between the accepted contract amount, the contract price. Contract price is the final after the variations and claims, whatever is going to be. It is going to be the contract price. The accepted contract amount is what is mentioned in the agreement, which is signed between the parties. So the retention is usually the 5% of that amount. So you have to ensure that the 2.5% or the 50% of the 5% remains with you as a liquid cash at the time of issuance of statement at completion. On the other hand, if there is any advance payment which is still balanced, you have to adjust the advance payment in the statement at completion. While in the final payment certificate, you have to pay back everything. You have to give back the retention money or any other, and also adjust if the employer thinks that he's actually eligible for some money. So the parties, they can review, they can agree, and this also has to be settled. Clause 15, termination by the employer. Subclause 15.1 states that the employer can terminate if any obligation is not met by the contractor. So this subclause actually gives, you can say, a blanket right to the employer, that if he thinks that this actually the subclause 15.1 is notice to correct. So what is notice to correct? That if the employer thinks that there is any obligation in accordance with the contract, either it is in connection with the permanent works, or if it is in connection with the or temporary works, any obligation in accordance with the contract, if the contractor is not fulfilling, the engineer, he shall issue the notice to correct. And notice to correct is a prerequisite to subclause 15.2, the right to terminate. So 15.2 says that the employer can terminate for other reasons, and the reasons are if the contractor abandons the works, and he doesn't do anything, and he demobilizes apparently. The contractor becomes insolvent or bankrupt. The contractor subcontracts whole of the works. I think we have discussed this before. If he subcontracts more than 35%, or let's say that the whole of the works are subcontracted by him, and he's trying to escape from the obligations, yes, he has all the rights to terminate him. But for all of this, there has to be a 15.1 notice to correct. So you cannot terminate directly. I think maybe only if he becomes insolvent or bankrupt. So that's where I think no notice requirement is there. But except from that, if there is a performance issue, so he shall give a notice to correct, or maybe and give him some days. Let's say that 40 days or 28 days to correct this, or to start working on this. Okay. And if the contractor commits fraud, yes, even this is an offense. So if he commits any fraud, he can terminate directly. Subclause 15.3, if let's say that in accordance with clause 15.2, the works are terminated, the engineer, he has an obligation to value the works and calculate sum due between the parties. So if there is anything to recover, if there is anything to be paid back to the contractor or to be recovered from the contractor, he has to value everything. Subclause 15.5, the employer can terminate for its own convenience, but cannot deliver the works itself or contract with any other party. So this subclause actually obliges the employer to, if he's terminating the contract, if it means that he's abandoning the project, you know. So he cannot later on, just because maybe the rationale behind this is that maybe he sees the prices of the contractor are very high and he just discovered it, and let's say that it's only 6 months from the contract and he want to terminate the contract for his convenience. So he can do it for his convenience, on convenience, but when he maybe he has a bigger development and he just now the idea or the development has changed, now this project is not required anymore, then he can terminate, and he can terminate at any time, you know, but not for the sake of giving it to any other cheaper contractor and get this work done. So he cannot do that. If the contractor he sees, or if he has any evidence saying that, so he can sue the employer, maybe for all the profit or all the cost he could have incurred. So I mean, expect that a big claim may come from the contractor if you terminate him for the convenience and you bring any other party to do this work. So that's why, you know, we have discussed this, that the parties are the contract are designed in a way that the parties are equally they have the equal bargaining strength. Yes, and there we go, the equal bargaining strength, the equal right to suspend and terminate by the contractor as well. So let's see that what are the rights the contractor he has. So subclause 16.1 says that the contractor can suspend or slow down in below cases if the engineer fails to issue the interim payment certificate and the employer fails to pay. So I think we have discussed this in clause 14, that even IPC in accordance with clause 14.6 is an obligation on the engineer, and the clause 14.7, the payment is an obligation. It's not, let's say, a choice for the engineer and the employer. So it's an obligation. So that's what creates the contract creates obligation on both the parties, not on one party. So the employer he has to pay, the engineer he has to issue the IPC. If the employer failed to provide reasonable evidence of his financial arrangements, yes, this we have agreed, or this we have actually discussed in subclause 2.4 as well, that the employer he has to give the reasonable evidence to the satisfaction of the contractor. So if he fails to give any satisfactory evidence or reasonable evidence, this actually gives the right to suspend the works. It's very serious, by the way. Subclause 16.2, the contractor is entitled to terminate in below cases if, yes, again, the engineer fails to issue the payment certificate within 56 days of IPA. It's not that he terminates within 56 days of IPA. It is if the engineer fails to issue the payment certificate within 56 days. You know, the contract gives the engineer 28 days, but in case of termination, there is some more time given to the engineer. Maybe he has some management issues or some issues like that, and he has an intention to certify, but it's just the process taking time. So also like we have the notice to correct, a prerequisite before the termination. Same way, the contractor he shall not terminate without any notice in most of the cases. So he has to give the notice that yes, I'm being delayed. You know, I have expenses, or maybe I will incur some additional costs. So please pay me. So within 56 days of the IPA, the engineer he has to, if he has not issued the IPC, he can terminate. The contractor can terminate. And if the employer fails to pay within 98 days, so 56 plus some more days being given to the employer to arrange funds and pay the contractor. And sometimes the employer can just say that yes, I have some issues with the funds, or I have issues with the bank. The funds are coming in this date, and it can be more than 98 days as well, because the parties are working in good faith. So the contractor he can resume the work in good faith, that on the promise that he will get paid within the date stated in the correspondence by the employer or by the engineer. So but if he fails to do that within 98 days, within 98 days, he has the right to terminate. The employer failed to provide the reasonable evidence of his financial arrangement. So this is a very serious thing that the employer shall not take it very lightly. That the contractor, he should understand, because I'm renowned and I have a big name, so I will pay him. But if the contractor asks for a financial arrangement evidence, you have to give it. If there is a prolonged suspension, if the suspension is there for, let's say, for the works are suspended for a period more than 140 days, or let's say more than 80 days, so he can terminate immediately, with notice, that without even giving the date, he can just terminate. Let's say the works are suspended for 80 days or 85 days. On 86 days, he can just say that, yes, I terminate the contract. The contract is terminated from my side, so he can leave the site, and he's rightful. The employer become insolvent or bankrupt. Yes, this is something, even in the case of contractor or employer, it gives the immediate right to terminate. In both the cases, if let's say the contractor becomes insolvent or bankrupt, or the employer becomes insolvent or bankrupt, immediately with notice that I am terminating the contract due to this reason, which is they have an evidence that the employer became insolvent. Clause 17, risks and responsibilities. Subclause 17.3. This is very important subclause, and we have discussed this before as well. This states the employer's risk. So sometimes the employer can amend if the parties, they agree between themselves, and the contractor, he want to take some kind of risk, or maybe you want to increase his price in bargaining of some of the risks by the employer. So this can be reduced. So this is let's say a standard risk clause. The risk detailed here are employer's risks. For example, if there is a war, hostility, rebellion, terrorism, or riots, so the contractor will be obliged to get cost and time, and maybe profit as well. So because this is deemed considered as the employer's risk. It's not from the third party. Let's say the war, for sure the employer is not going to commence any war, or because of any war. So there will be a third party, or there will be some other events, but still it is his risk. Occupation by the employer, I think no need to even discuss about this, that if the works are occupied, or the area of the site is occupied by the employer, so it is apparently, and for sure it is his risk. Design of the works, if there is any problem with the design of the work, it is expressly his risk. Only in the red book, not in the yellow book, or in the silver book. So this is his risk. He has to take this risk. Unforeseeable forces of nature. There is rain, for example, or there is any storm. But there has to be, there is a degree of unforeseeability. So it has to be. I think if maybe you have heard it or read it before, that for an event to be unforeseeable, or let's say exceptional, it has to occur maybe one time in last 10 years. So you have to get the data, for example, from the meteorology department of that country or that city. And let's say that if it is happening every other year, so an experienced contractor should have foreseen this. So the degree of unforeseeability, it's not very open for the contractor. So there has to be some gauge to this unforeseeability. Clause 18, insurances. Subclause 18.2 states that if there are any damages to the work, the contractor shall give or pay back all the full replacement value of the works. So usually you will see the car insurances or the contractor or risk, they are actually in accordance with the requirement of subclause 18.2. Subclause 18.3, if there is any injury to third party or any property damage, so there will be a third party liability insurance. So that will be the effect of that insurance will be in accordance with subclause 18.3. Subclause 18.4, injury to the persons working on the site. So you will see workman compensation insurance. Let's say that if during the works any any employee or any other person, if he becomes injured because of the performance of the work. So he will be compensated through WCI, Workman Compensation Insurance. Subclause 18.5, if in case of some design and build contract, or let's say the silver book contract. So if there is any damage arising from the design issues, and to cover them, the contractor, he's supposed to have the professional indemnity, not the employer. The work designed by the employer have no such requirement. It's only the requirement of the work designed by the contractor in the red book or in the yellow book. Subclause 2020, it's very important. The claims, disputes and arbitration. Subclause 20.1, the contractor to give notice to the employer not later than 28 days after the contractor should have became aware of any event giving rise to an extension of time or additional payment. So actually the concept of this subclause is based on a legal let's say a legal concept, law of restitution. Maybe you have heard about this. The law of restitution is basically based on the recovery of the damages. So law of restitution says that the parties shall be brought back into the same position they were before the occurrence of the event. So it's not an opportunity to make money, the claim. It will be as far as you have proved with the evidence that, and there has to be a rationale that this was the cause and there is an effect, and the impact of the effect is how much, and there is some substantiation, there is some reasonable evidence. If you can justify or demonstrate all of this, yes, then you have the right. But it is only the recovery of the cost. So the law of restitution is that the parties shall be brought back into the position they were before the occurrence of the event. Either it is from the contractor or the employer. So sometimes the contractors, they think that it's an opportunity to make money, while it's not. We'll discuss further actually 20.1 in next two slides. The contractor to submit a fully detailed claim within 42 days of the event. So sometimes if the effect continues for more than 6 months, or so, he shall submit every month the interim particulars of his claim. Subclause 20.4. If the parties are dissatisfied with DAB decision, as we have discussed before, that any determination of the engineer, if it is not accepted means dissatisfied. Accepted, they have to accept. The parties, they have to give effect also to the engineer's determination. So if the parties are dissatisfied, so the matter will be referred to the DAB, and let's say the DAB, they have given a decision. And again, one of the parties are dissatisfied with the DAB decision. So within 28 days of the receiving of the decision from the DAB, they can issue a notice of dissatisfaction to the other parties and to the DAB as well. So the dissatisfaction notice in accordance with clause 20.4 will commence the arbitration within 56 days from the notice of dissatisfaction. So the matter will further go to the dispute resolution, the ADR, the other method of dispute resolution. Arbitration is also one of the adversarial dispute resolution methodologies. So it will be 56 days from the notice of dissatisfaction. Until the 55 number days, the 55th days, the parties, they have a chance in accordance with the contract to settle the amicable the issue or the dispute amicably. So the dissatisfied parties may settle the dispute amicably within the 55 days from notice of dissatisfaction. So even 1 day before the commencement of the arbitration, if the parties, they decided that because the fact is that arbitration is very expensive, So the parties, they can maybe they are seen enough, and they can do a gentleman agreement between each other, or a settlement agreement in accordance with clause 20.5, and settle the dispute amicably. Next slide. Yes, this actually just to is an illustration of the claims, the contractor's claim in different clauses that it give rise to what. But before going to this, I'll just give you let me create an understanding that in Sharia law, for example, in KSA, there are very less chances that you'll get the profit, you know. So usually, mostly it will be time and cost, but maybe the new civil transaction law, maybe there is a provision in that to get paid for the profit. But the profit or any intangible uh, amount or money which is not yet there, or you cannot or the contractor cannot prove the harm or prove the tangibility that this is the exact profit which I have lost, or the profit is there, you know. So until then, maybe he'll not get paid for that. But this is the understanding of the FIDIC. Delayed drawings or instruction. If let's say the if in the employer's design, if he had delayed some drawings for any part of the works, the contractor is entitled to get paid in accordance with clause 1.9 for time, cost, and profit. And even the instructions, if there are any delayed instruction from the engineer, let's say, so he can get compensated for in accordance with subclause 1.9. Access to the site, as I told you, it's a blank check in my opinion. If you the more you delay the access to the site, and there will be consequences. Setting out, you know, if there is any issue with the setting out of the works, you know, and the drawings or let's say the area of site or the drawings given to the contractor, they contradicts with or they are landing in the other properties where which is not the site. So or any other setting out issue, this can be entitle the contractor to time, cost, and profit. Unforeseeable physical conditions, I think we have discussed this in subclause 4.12. Testing on completion. Let's say that there is an inspection and testing plan from the contractor, and it is agreed. So he will the test on completion or the testing and commissioning at the completion stage. There is a pool of tests which is required from the contractor. But let's say the employer or the engineer, they want some additional tests or some tests which are not mentioned there, or which are not required there. So this can entitle the contractor to additional time and cost, because test on completion shall be before the completion date. So for sure he will be entitled to extension of time also. The contractor's entitlement to suspend. Let's say that we have discussed the reasons for which gives the entitlement for the contractor to suspend. This is, I mean, suspension of works, or let's say the delayed payment, delayed issuance of IPC, or delayed receiving the payment as agreed in the contract. So if he the contractor, maybe he suffered some let's say that the profit or not profit, sorry, I mean some additional cost for his funds. So or any other cost which he thinks that and if it is allowed by the law of the country, so he'll get paid for that, and he will be entitled in accordance with FIDIC. And then these are some employer's risks. So any delays caused by the authority, also this is one of the employer's risks, although it is not mentioned there in 17.3. But if there is if you go to subclause 8.5, it is very clear that the contractor is entitled to time. If because the contractor, what they will do, that they will for the permits and let's say that they want to get some permits from the municipality, and they will allow some time in their program for that, let's say 50 days, but the authority they just took maybe 100 days. So for sure the you cannot I mean consider this as employee's delay. So neither it is from the employer, but still, I mean, it is one of the employer's risk. And that's why the contract says that you have to assist the contractor, you know, to get the permits or the permissions from the authorities. So he will be entitled to the time. Consequences of suspension, you know, if the employer suspended the work in accordance with 8.9, yes, for sure, all the standing equipment, the labors, for sure the contractor he has to pay them. Unless it is very clear that until the suspension is up to which period, so he will try to mitigate the effects of the suspension, but still he will be entitled to time and cost. Variation orders, yes, if you have given the additional works to the contractor, he will be, he's eligible for time and cost and profit. Not only the one which is issued inside the variation order, but maybe this will have an effect on his resource planning for the other works. Sometimes the variations are maybe 50% of the value of the original work. So the contractor is not, deemed to have mobilized all the staff. So sometimes, he will maneuver, he will bring some staff from the current permanent works, or he will plan the resources in a way that yes, he will complete this work and plus the variation. So in order to do that, he will lose some time and the cost as well. So yes. So the concept about time and cost is that what I've said before, that we have to bring back, the law of restitution says that we have to bring back the parties into the same position they were before the event. So actually, the rationale for the cost is very clear, that we'll pay them the incurred cost. Whatever the cost is incurred, we can pay them, and it is very much tangible. The time is the time, it has no physical value. So you have to give this in the future. So that's why there is always extension of time. So you have to understand this concept. The time is also the in accordance with the law of restitution. So we are trying to bring back the parties to the same position they were before the event. Damages arising from war, riots, 17.3, damages arising from Employers Acts. This will, from the Employers Acts, these are compensable delays. So these are, they will be subject to time entitlement or compensation for time, cost, and profit in the jurisdiction they are. This facility is available, or it is permitted by law. Delays arising from war, riot. So why it is mentioned in the force majeure, 19.5 is force majeure, one of the subclauses of the force majeure. So because sometimes the employer, maybe they will not take this risk. So even if the subclause 17.3 does not give the entitlement, so the contractor will have the entitlement in accordance with subclause 19.4. Delays arising from natural catastrophes. So this will give him entitlement for the time. So by this, we ended up our presentation for today. Thank you very much. And I believe we'll have questions, many questions. I can see some in the chats.
Thank you very much, Babar Saab. Really informative and well-delivered session. And thank you for sharing your knowledge and real life experience. I believe we are a little late with the schedule, but as the delays from the organizer side, so we have to allow extension of time if you permit, so we can start the question and answer session.
Yeah, exactly. You can have an amicable settlement, please.
Thank you.
Yes.
If anybody have a question, you can just unmute your mic and you can ask directly. And later on, we can answer the question in the chat box as well. So first, start with the audio questions. If anybody have, just you can unmute and ask directly.
Assalamu alaikum, Babar Saab.
Wa alaikum assalam. Yes, Mr. Ali Raza.
I had a question about subclause 3, the appointment of the engineer. I wanted to ask that can we appoint a single person as an engineer, or sometimes we have seen the employer is appointing the engineer from their firm, not an independent third party. So is it viable to appoint an engineer from the employer's team, or it is prohibited due to conflict of interest or something? Thank you.
By the way, yes, you can say that. I mean, it's not practical to have a person as an engineer, only. Usually you have the let's say the whole of the organization, they have an experience working as FIDIC engineers, and they know the system, let's say that if the employer he knows about it, but still maybe there is an element of let's say that there will be some biasness, maybe. And if as long as the engineer, if it's a person or a firm, they can implement or they can administer the contract actively in accordance with the contract, and they can maintain the balance of the fairness, and they can issue determinations which are fair and which are in let's say that not benefiting any specific party. So I think it can be okay, but actually I haven't seen, this is very seldom I've seen that a person or one person will be the engineer. This is very impractical. I would say that it's sometimes it will be very impossible for him to administer the contract. It is advised, that's why, that you have a full organization as being appointed as engineer.
Right, sir. Thank you. My second question and last question about the program, as you said, it is a consented program, not an approved baseline. And we also saw under subclause 8.6, I guess, they have to submit a revised or a recovery schedule. So let's say they have to do a delay analysis. So on which program we will do the delay analysis? On the baseline program or the recovery schedule, if the delay occurs after that? Because contractor has already, recovered his delay in the recovery schedule. So they will say, I will do delay analysis on the recovery schedule, not the baseline. So what should be the correct method or the correct program to choose for delay analysis?
Usually, it depends upon on the stage of the project. Usually, if you go to the Society of Construction Law, and if you see their the advices they have, it is very much mentioned there. That at which stage which program is suitable for the delay analysis. So I mean, as long as if the recovery schedule is giving the true analysis of the extension of time or the situation we have on the project, yes, we can, yes, because the contractor he has mobilized his resources in a way that the anticipated delay has been reduced. So eventually, but let's say that during the process, the result is not coming as anticipated, or it is not the true result. So I mean, in accordance with the Society of Construction Law, if it is, I mean, let's say we are in the start of the project. So let's say we'll have a crashed baseline or impacted baseline. If we are at the end of the project, we'll have impacted what you call it, the final program or the actually I cannot remember the terminology. The final program, the complete as completed program or as built program.
As built.
Yeah, as built program. So, or sometimes they will advise time window analysis. So actually, it's I mean, as long as you get the right result from the program, it is, and sometimes the people, they approach the program very scientifically. It will give the scientific result, the program. But sometimes still there is a lot of room for the engineer to do a fair determination. Sometimes maybe the definitions of concurrent delays is not as per the industry standards in the contract. Maybe the contractor is usually he shall be compensated for the time for the concurrent delays, but maybe some parties they will actually deny the time also. So this may result in leaving or application of the delay damages to the contractor, while the other parties was also delayed. So that's why actually it depends upon the result, how the result is, and how well the engineer actually he assessed it.
Exactly, sir. Thank you. मेरा भी इसमें ये opinion था. Depending on the stage of the project and depending on the delay analysis method which best suits at the given conditions,
exactly,
we can choose that.
Yes.
Many thanks. Thank you.
Thank you. Thank you, Mr. Alriza. Yes, I think Mr.
Hello.
Yes, who is this?
Assalamu alaikum. Zafar
Alaikum
Tabassum
salam.
with you, Mr. Babar Arshad. You can hear me?
Mr. Zafar Tabassum. Yeah, I can hear you. Yes, please.
This is the second or third time I saw you before in some interviews, mock up, mashallah. Today
Thank
I saw
you.
different Babar Arshad, mashallah, with full knowledge and inspiration. Really,
Thank
it's
you.
good toward the
Thank you.
community. This is my compliment.
I hope that there was something something new to understand from what I have actually I was trying to deliver.
Yeah,
Just an
that's
understanding actually. Yes.
yeah, that's great, really. Just one point of discussion, maybe you can elaborate for our knowledge enhancement. Now, as you know, I'm working also in KSA. And the previous question from our friend, he is asking about the engineer. Now here the setup or the system is totally different. I saw three parties, like one is the designer and other is the along the, like one is the employer, then designer, then PMC. And under PMC, we are giving the project management consulting plus site supervision. So where that engineer disguises?
Actually, I think it's not a standard contract or a FIDIC contract which you have implemented on your project. I think actually it's the system which works. Yes, if the contractor he understands his position, he understands the contract he's entering into, and he understands his right. So if there is no engineer, even in the work designed by the employer, and if the contractor thinks that he can survive under these conditions or this environment, yes, it is again it is to the discretion of the parties. So we cannot have FIDIC in all over the world. Yes, FIDIC is mostly there in most of the projects, and because most of the organizations, they are well aware of FIDIC and their staff is well aware of FIDIC, and they have an understanding working in the environment where FIDIC is implemented. So that's how the FIDIC gained popularity. But it's not mandatory to be, and there is no mandate for the engineer to be everywhere in the contract. Maybe the parties, they don't have any issues which shall be determined by the engineer, or the contract is written in a way that the risks are transferred to a certain party, or the party, they know that yes, we are going to get compensated, even it is a very onerous contract or one-sided contract. So that is my understanding, I would say, about the setup you have maybe in any other project other than FIDIC, standard FIDIC contracts.
No, unfortunately, it's mentioned FIDIC, engineer name is mentioned, but overall is the employer. And there is one very typical clause. I hope you have come across, is a unilateral. Any variation if contractor does not agree, the employer is making determination unilaterally, and contractor obviously has signed the condition of contract, so he has to be agreed on this. Plus, we are saying it is determination. So it is something, new model, PMO, and
yeah, exactly. It seems a very unilateral contract. I mean, it's not. I mean, engineer. It seems that okay, you have certain conditions from FIDIC, but it is highly or heavily amended FIDIC. So it cannot be called as FIDIC. If the parties, they cannot exercise their rights in accordance with FIDIC. FIDIC gives the equal rights to both almost equal rights to both the parties. So if they don't have that there in that contract, it means it's a unilateral contract, and the parties they know each other while they were signing the contract, that because contract is the law between the parties, so they were well aware that what kind of risk. Let's say if it is the contractor who feels that I'm losing my rights, so it means that he should have been aware of this thing when he was entering into the contract.
Yeah, so I will request chairman and yourself to work. We all to work together to put in alignment KSA mostly contracts to at least compete UAE, right?
Yeah, but again, it's mandate of the government actually. How they want to they want certain contracts at certain location to there are many other aspects, to enter into a certain type of contract in some parts of the world. So maybe there is a rationale behind that. So I mean, yes, we can influence only by way of having such seminars or webinars, where we can create more understanding about the standard FIDIC contracts or standard any standard contracts. I think this is the only tool we have, create the awareness and create understanding.
Sure,
I think
sure. I
we
appreciate.
are
Thank
doing
you
that
so
bit.
much.
Yes.
Yeah, I took a lot
Thank
of
you.
your time all as well as the audience. Thank you so much, Babar.
Thank you. Thank you. Thank you very much. Thank you.
Assalamu alaikum, sir. Here is Ishfaq Ahmed.
Wa alaikum assalam. Yes, Mr. Ishfaq. Yes.
Sir, how are you?
I'm fine. I'm doing great. Yes.
Mr. Amir, how are you?
Mr. Amir, how are you?
Sir, I have one
good,
question.
Alhamdulillah, Ashfaq sir.
Okay. I have one question, sir. Here,
Yeah.
according to class 4.4, there is a contract volume of the percentage of the work, 25% or 30%. I was asking
35%. Yeah.
this 25% or 30% is according to amount or according to volume of the work?
By the way, the way it has been mentioned, I think it's the value of the work, not the volume of the work. It is the value of the work. 35% of the contract. Sometimes you can say that okay, the volume is very little but the items are very expensive. So what you will do then? Yeah. So it is. I think it is the value. Although it is, I have to recall, because I have seen this maybe. 3 years back, I stopped seeing the government tender and procurement law, and it was last update maybe in 2019, or I cannot remember. So at that time, I've seen it was 35%, but I cannot recall that exactly it was amount. But I understand that it shall be the amount, because some works maybe they are very important, but they have less value. They are very critical. But some works maybe they are very small in volume, but they have a bigger value.
Yes, that's right. Okay. And the second question is, suppose if contractor submitted the invoice as per the contract, but consultant reject the invoice. Suppose in my experience, I will tell you that one contractor submitted the invoice, but I rejected the invoice due to performance certificate because they did not provided the performance certificate. So I think that was according to the contract, I think, because I think in the FIDIC they also mention in performance security or performance bound clause that if contractor did not submit the performance security within the stipulated time, then engineer have right to reject the invoice or return back the invoice. So I think that is my correct action that was.
Yeah, see, I mean, in order for the engineer to certify, there are some requirements. What are those requirements? Yes. The performance certificate has to be in place, has to be valid. The advance payment guarantee has to be valid in place. The insurances has to be valid in place. I'm not sure about the insurances, by the way, but the advance payment guarantee and these has to be valid. The works has to be in accordance with the contract, and there are some other small requirements, so then the engineer will be enabled to certify the payment. But if he's not satisfied with all the requirements, yes, he has the right to reject, and it's not that the engineer is prohibited. If he has valid reasons, yes, and the cycle will start again from the contractor is supposed to revise his payment application, and he will submit in accordance with clause 14.3, and he will submit again.
Yes, because according to FIDIC, I think there was two main reasons. According to that reason, you can reject the invoice. One was performance security if they did not submit or if that is expired. And second is if the work done is not according to the specification, then engineer have right to reject the
I think we have
invoice
discussed.
accordingly.
Thank you.
Okay, sir. Thank you.
Thank you. Yes, please.
Babar Sahab, I
think
believe we shall close now, because it's getting really late. Yeah, getting really late. It's very broad topic. There could be discussion, throughout the night, or long discussion. So remaining questions, I believe whoever have any question, you can post in the chat box. There are some already.
I think
we can
have
answer
some
those
questions in
questions.
chat box. So yeah, we can answer these questions later on.
Yeah, sure.
You can
so
see
if anybody
some
else have
questions.
any more questions, you can post in the chat box, and inshallah we will answer all of those questions. So just let me close now. Once again, thank you so much, Babar Saab, and thank you to all of the attendees. Despite announcing on a very short notice, still there was a really good turnout. I believe it was more than 50 people who attended the session. So thank you everybody for sparing your time. And please follow our LinkedIn page, and I believe most of our attendees are our member already from the group. So just follow, our any announcements for the future webinars. And once again, thank you so much for your time. Thank you, Babar Sahab.
Thank you, everyone. Thank you, Amir Saab. Thank you for arranging this. Thank you. Thank you, everyone. I hope you get something from today's session. Thank you.
Sure. Thank you.
We will answer these questions. I think we need to copy all these questions, Amir Saab.
I will copy it. I will manage.
Yeah. We are going to issue the certificate. Yes, I know that now it's a requirement. The APC requirement as well. So yes, we'll do that.
Just one thing, Babar Sahab, if you can confirm, somebody was asking that can we share the slides on our page or in the group?
Yes, in the group we can do. Yes, in the group, but not on the. I mean, we can do after some time. After some time. So sure. Yes, we can do, but not now.
Okay.
Thank you very much.
Yeah,
Thank you, everyone.
Now. Thank you, everyone.
Thank you.
Bye bye. Good night.
Assalamu alaikum. Happy Ramadan. Thank you. Assalam.